basically, case law in California says a trial court may still vacate a default on equitable grounds, even if statutory relief is unavailable. And that was in the case of Oliveira versus Grace. And basically, I take this to mean that even if you can't find the statute, you can still go back to the court and you can ask the judge to get rid of this judgment, so long as you have some relevant case law and you have some really good facts to back up your claim. Right now, me being pro se, I find that you always want to do your homework, and you can present that to the judge and you can pray that they will grant you relief based on that. That's always going to be better than simply going into court empty handed, not knowing the law and not having done any research. It's really up to the whims of the court whether or not they're going to give you any relief. But some situations, in my opinion, I want to say in Illinois, up to 50 to 60% of people who go to court are pro se. And because of this, their judges aren't supposed to do this, but because of this, they give a lot of pro se litigants leeway. But on the flip side, sometimes judges and lawyers take advantage of pro se litigants, right? So you're always better off doing your research if you're pro se and going into court with ammunition. The ammunition is going to be knowing or having some understanding of the statute and knowing and understanding some of the case law that's involved in your case. Now, with that said, none of that is going to compensate for skill. One of the, I guess, the unfortunate things about being pro se is that you typically wouldn't have the skill it takes to litigate something. And you should consider getting a lawyer. There's several reasons you want to consider getting a lawyer. And that's one of the reasons is the fact that a lawyer is going to have skills. So from my understanding, when you have a lawyer, that lawyer has gone to school and that lawyer has done some exercises in school to prepare him for his profession in law, right? So if we want to look at the analogy, or we want to use sports as an analogy, we can choose basketball. Sure, you can go and read up on what a foul is. You can read up on what traveling is. You can read up on what a two-pointer and a three-pointer is. You can read up all the rules of basketball, but the reading is not going to give you the skill. The only thing that's going to give you the skill is practice. And if you're not practicing basketball, it doesn't matter how much you know, you're still not going to be able to perform as well as someone who's studied and practiced over a course of years. Now, so that's the benefit of hiring a lawyer. I like to know what you think about hiring a lawyer. Leave your questions and comments below. So on the flip side, reasons you may not want to hire a lawyer is because, as the gentleman basically said, is that he's wasted tens of thousands of dollars, and from reading the post, he probably feels that he hasn't gotten anywhere. So yes, you're hiring someone who has the skill, but it doesn't necessarily mean that that person, that lawyer, is going to put their skill and their expertise in exercise for you, right? So you could be potentially taken advantage of, or you could potentially get nothing in return for your money when you're hiring a lawyer. So, these are some of the things to consider when you're trying to figure out whether or not you want to hire a lawyer. Me, myself, my default, I think my logic for whether or not to hire a lawyer, I look at the type of issue that I'm dealing with, and then I ask myself, how expensive would it be to pay for a lawyer? And then I try to figure out whether or not the law is accessible and it's easy for me to understand and it's easy for me to argue my case based on how well I know what's going on. But the biggest factor is whether or not there is some corruption. and it's really tough. I just find that in the family law system, there's lots of corruption, and it really doesn't matter if you hire a lawyer or not. You're still going to end up with a certain judgment. So in that situation, if I feel that the situation is almost impossible, then I'm probably not going to hire a lawyer, because I feel as though if I hire a lawyer, the lawyer is just going to come in and milk me, and they're just going to go through the motions and pretend like they're doing something, when in actuality they're not going to do anything. You're still going to end up with the same judgment you ended up with if you had not hired a lawyer. So what's the point? On the flip side, if I'm up for murder or some crime like that, then I'm definitely considering hiring a lawyer, because I don't want to necessarily risk, spending the rest of my life in jail, uh, when I know for a fact I don't have a mastery of the law, right? So there's a lot to consider whether or not you're going to hire a lawyer. But, honestly, most things I would handle myself, with the exception of whether or not it's going to eat up, too much time and money. So in Illinois, they actually have a law that says you can hire a lawyer, but not have the lawyer to represent you. Excuse me. Not have the lawyer represent you, but you're bringing on the lawyer so you can get some counseling, and you represent yourself, and you can unbundle the service, and you can have the lawyer do specific tasks. I like that option. I don't know if that exists in California, but it exists in Illinois. And I would consider something like that if I was this individual. Excuse me. Having a lawyer under an unbundled agreement. The lawyer doesn't represent you. You're giving tasks to the lawyer, and the lawyer is doing specific tasks for you. Now, in Illinois, although that law exists, I just find that most lawyers won't work in that fashion. And I believe they choose not to do so because they don't have control over you and your case. And if they don't have control over you and your case, they don't have the ability to milk you for thousands of dollars. Right? So just moving on. The other thing I found interesting about California is that they have something called the writ of coram nobis, right? And I'm not going to read all of this to you, but I'm going to read some of it just so you can get an understanding of it. And I also say that the writ of coram nobis is pretty much abolished in Illinois, just giving a comparison here. And I think the reason for that is because the statutes that Illinois has makes it unnecessary. So let's get into the writ of coram nobis, right? And I don't even know if I'm pronouncing this right. If you're a lawyer, or you're a Latin expert, questions or comments below and let me know how to pronounce this, right? But the case law goes on to say the writ of error coram nobis is a non-statutory common law remedy whose origins trace back to an era in England, which appeals and new trial motions were unknown. So, you couldn't appeal in New England, and there was no such thing as a new trial in New England in this time. Far from being constitutional origin, the proceeding designated coram nobis was contrived by the courts at an early epoch in the growth of common law procedure to provide a corrective remedy because of the absence at that time of the right to move for a new trial and the right to appeal from the judgment. Right? So this ancient writ allowed you to go back to court to fix judgments against you. Right? And then it goes on to say the grounds on which a litigant may obtain relief via writ of coram nobis are narrower and on are narrower than on the basis of habeas corpus. And then it goes on to say the writ's purpose is to secure relief where no other remedy exists from a judgment rendered while the existence of some fact which would have prevented its rendition if the trial court had known it, and which, though no negligence or fault of the defendant, was not then known to the court. So in other words, the writ of coram nobis allows you to bring in facts that you discovered after the court hearing, right? So you go to trial, you have a hearing, you lose, But after losing, you figure out, or you come in possession of some information that wasn't available to you when you had the trial. Then you can go back and say, hey, judge, look, we had the trial already, but this new information was recently released, or it just came to light. I didn't know about it before, but this new information exonerates me, right? So please, can you vacate this judgment? So we see this type of thing all the time, where you have those people who were locked up in probably the 1950s or 60s or 70s, before the advent of DNA. And now that DNA provides more information, people are able to use DNA or new DNA techniques to go back and say, hey, look, this new technique came out, it's solid, and basically I would like to have a new trial, have this judgment vacated, because of this new DNA evidence that wasn't available when the trial happened. Now, this is not limited to just DNA. It could be anything, right? So long as it's solid information that wasn't available at the time of the trial. Now, keep in mind that the writ of coram nobis isn't necessarily limited to new information. It's basically allowing you to go back for any other reason, right? Basically, this is something that you're going to use before you appeal. So I guess to sum this video up, what I probably should have said in the beginning. Actually, I should have said a couple of things in the beginning. Some of which I've already said. We talk about jurisdiction. If a court has put a judgment in against you and it didn't have jurisdiction, then you have a right to go back to court and get that thrown out. Now, when the court puts a judgment in, and after a specific amount of time elapses, the courts lose jurisdiction to modify your judgment. And you also lose the right to appeal. So I think California, there's a 90-day period of which you can go back and ask the court for a new hearing or amend or vacate a judgment. But of course, you have to notify all the parties involved, right? So there's that. And then, the other thing is that you can ask the court to vacate or amend the judgment for any other reason. And I get into what that means in the first two videos in this series. Definitely check them out. But I think I'll go in a little bit more on the writ of coram nobis. It goes on: the principal office of the writ of coram nobis was to enable the same court which had rendered the judgment to uh, reconsider judgment in this case in which the record still remained before the court. The conventional language of the writ in the King's Bench makes reference to the record which remains before us, the King, Q coram nobis, resident. In the common pleas, the form of the writ was coram nobis before you, the judges. So, essentially, you can before. So after, so one of the things that I really want to stress here: the way he asks a question is that he believes that after the judgment, you go directly to appeals court. Now, I don't know much about law in general, right? But I do know in Illinois, generally, you want to file a post-judgment motion, such as a motion to reconsider, uh, a motion for amended judgment, a judgment for rehearing. These are all some of the wordings, and there are specific statutes to address each of them before you go to appeals court. And I'm going to say that in California, it's probably going to be the same. You don't want to rush and go directly to appeals court before you ask the court for some type of prejudgment relief. And I believe the reason for that is that you want to give the court a chance to correct any possible errors that it could have made, right? So I guess what the gentleman should do, he should go through his judgment, and he should go through his case and look for any errors that were potentially made in his case. And if he finds any potential errors, then he can ask for relief based on that. Relief being vacating the judgment, having a new hearing, modifying the judgment, so on and so forth. So one of the things that he's disappointed about is that, he has a judgment against him for 30K. There is a chance that he can have the judgment modified for a lesser amount, so on and so forth. The other thing that he can do is he can look for constitutional violations in his proceeding. And we're not going to try to go through all that right here and right now because I don't even know what his specific situation is. Right. So you can look for errors, you look for constitutional violations. And finally, what he can do is look for potential things that can be considered unjust or unequitable or just simply unfair. If the judgment is unfair, that in and of itself can be a possible grounds for asking for relief. So these are generally some of the things that you can look for in California. I'm 100% sure there's more statutes out there. I just wanted to give kind of like a condensed versions for the purpose of this video. If you want more detailed information, go back, watch the first two videos, how to escape a court judgment. It will give you some really good guidelines on what to look for. And then you take that information, you find the specific corresponding statute or case law for your state, and you use that to draft yourself a petition or motion to modify the judgment or to vacate the judgment or to have a new trial. Thanks for watching this video. Please leave your questions and comments below.